If your asylum case has been pending with the government for years and you want to get it over with, then this video is for you. I'm going to discuss with you strategies that you can use to get the government to take action on your asylum case. If we're just now meeting, I'm Brian Manning, and I'm a political asylum lawyer. I help people all over the country secure their future in the United States through asylum. I used to actually be an asylum officer with the government, and I use the insights from my experience of over 11 years with the government's two main agencies for refugee and asylum matters to now help my clients present the strongest case possible for asylum. So the strategies we're going to discuss today apply to people in two different contexts. There are those of you out there who have applied and who are waiting to get your interview. Maybe it's taken a year, 2, 3, 4, even 5 or 6 years for you to actually get your interview scheduled. So we're going to talk about that. And also the things we're going to talk about apply to people who have already had their asylum interview and now are waiting for the government to make a decision, to just give them a final yes or no. So there are kind of two routes that you can take for trying to get the government to take action on your case and either schedule your interview or give you your decision. And the first of these is if you're facing some kind of emergency, sometimes that can be a reason to get the government to say, okay, we're going to give you your interview or we're going to give you your decision. Most often this is a health issue. So for example, if someone, an asylum applicant, is under great stress and pressure, and maybe they've got a heart condition or some other condition that is made worse by the stress that they're dealing with and the uncertainty that comes with having this pending asylum application. And they can get their doctor to write a letter to the asylum office that says, hey, I think that this would be much better for this person's health if they could just get some certainty about their asylum application. And so those are the kind of medical emergency cases that will often lead the asylum office to expedite the interview, to go ahead and give the person the interview, or to get them to take action to try to resolve the case and get a decision issued. Also, if someone's family back in their home country is in danger, that can be another reason for the asylum office to speed things up. It's specifically for people that you would be eligible to bring here if you were to win asylum. So if you get asylum, you can petition to bring your spouse and your children who are under 21 years of age and unmarried into the United States on the basis of your asylee status. So if those people are in danger and you can prove it or at least convince the asylum office of that, then that may be a reason for them to expedite your case or to take action on it. You usually do need to provide some kind of proof of what you're saying is the emergency to convince the asylum office to move your case forward quickly. So that's using an emergency circumstance to get the government to act. Now, the other route is applying pressure. This is when you stay on top of the government and you ask them again and again, and you can actually escalate the intensity of the pressure that you're applying on the government to try to get them to act in your case. And this is all basically because the government is supposed to act on any individual case within a reasonable amount of time or a reasonable period of time. So you've applied for asylum. It's the government's job to actually do something with that application. It's their job to give you the interview. And if they've given you the interview, well, they're supposed to make a decision on it. So that's kind of the underlying thing that you're going to lean on to tell the government, listen, this is not a reasonable amount of time that I've waited. And that term isn't really defined, but really anything over a year, if you've waited more than a year for your interview or more than a year to get your decision after your interview, then you may be able to use this to your advantage. If we're talking about a wait of 3 or 4 or definitely 5 years, that's definitely too long. The government should have acted. And if you're at that kind of timeline where you've been waiting for 5 years for your interview or for your decision, then you've got a lot of leverage because that's not a reasonable amount of time. So how does this start? Well, this kind of pressure route, I advise going with a polite email to start, to just basically inquire about the status of your case. You can send this to the public email address of the asylum office where your case is pending and say, hey, I just wanted to check on the status of my case. It's been a really long time. I'd like to have my interview. Could you please tell me when I'm going to have it? And could you please go ahead and schedule it now? They may or may not respond to that. If they don't respond at all, follow up a couple of days with another email, the same thing. And then a couple of days later, if they still don't respond, and if they just still don't respond after that, or if they respond and just say, well, your case is pending, it's in line or it's pending, then it's time to take the next step and to escalate things a little bit. So what you can do next is you can threaten to sue the government. You can threaten to bring a lawsuit And it's important to note that if you end up doing this, you're not actually bringing a lawsuit to ask a judge to give you asylum or to even make a decision in your case. Rather, you're asking the judge to tell USCIS, which is the agency that the asylum office is part of, you're asking the judge to tell them, hey, do your job. You're supposed to give this person their interview, or you're supposed to give them their decision because you haven't acted in a reasonable amount of time, so you need to do it. That's what you would be suing for. So that is one thing that you can do after you've sent a couple of emails and it doesn't go your way, they don't give you what you want. You can send another email, and I would also send a letter in the actual physical snail mail to say, listen, this is not reasonable and you're supposed to act in a reasonable amount of time. Therefore, if you don't give me my interview and inform me that it's been scheduled within the next 30 days, then I'm going to have to sue you in federal court to assert my rights. This sometimes works because the government doesn't really want to fight a lawsuit. And so if you're telling them you're going to have to sue them if they don't give you your interview or give you your decision, that can be enough to prod them to actually look into your case and to maybe take action on it. Sometimes they feel like their hands are tied and they can't, especially if it's after your interview and there are security checks pending in your case that the government, like back at headquarters in Washington, is dealing with. Then the asylum office doesn't have a lot of leeway, but they can at least inquire with headquarters about your case. And sometimes that's enough to spur action. And let me add that with respect to the polite email that I suggest you start out with, sometimes that's enough to do the job, because sometimes, to be honest with you, your case just gets lost. It just gets sort of forgotten about. Your file may be sitting on someone's desk somewhere, and if you just remind the office that, hey, here I am, I still need my interview, that can be enough sometimes. I've seen that work where it's enough to get them to go, oh yeah, I guess this should be scheduled for interview. Oh yeah, we do need to finish up that decision and mail it to the person. So both of these things, just asking about the status of your case and telling them you want your decision or your interview, and then threatening to sue, can sometimes get the job done. So I get this question all the time when I raise the prospect of threatening to sue. Is it too risky? Are you going to hurt your case by threatening the government? And I understand that completely, that you could think, well, I don't want to come across as too demanding or too aggressive because then they'll hold it against me and deny my case because of it. I don't really worry about that. I really don't think that happens. I've not seen cases where I'm convinced that a person got a negative decision because they threatened to sue or because they did sue the government. I just don't think it's something that is normally held against you. In the United States, we're a very litigious society, which means that we sue a lot. We sue easily and often. So it's not that big of a deal. It's just not a big deal that you have threatened to sue or that you have sued. I think asylum officers understand. They know that people want to get on with their lives and they want to get their decision. So I don't worry about it. And I don't view it as a big risk or a big deal in your case. So after you've threatened to sue and they don't respond to you, if they don't respond at all, or if they don't give you what you want within the time frame that you told them they needed to respond in, like 30 days, then the next step is you got to decide, do you actually want to sue them? And you can do this by filing a lawsuit in federal court where you're asking a federal judge to tell the agency to do its job. And that involves usually just paperwork. You wouldn't normally have to go and make an oral argument in court, but it's a bit tricky. So I do suggest that you use a lawyer to do it. And actually, I suggest that you use a lawyer for all of these steps, just because USCIS does pay more attention when a lawyer is involved. I think it's just a fact that when they see that form that's at literally at the top of your immigration file, if someone has a lawyer, the form that says they have a lawyer with the lawyer's information is at the very top of that. So I think that tells you that they want to know who has a lawyer, and they give those cases a little bit more attention and are a little more careful with them. So I do think that you're more likely to get traction and to get people to actually look into your matter and to your request if you have a lawyer help you with all this. But you can do it on your own. So the process in court, usually or very often, when you actually sue the government, they give in. They don't want to fight this kind of case usually in federal court, especially if you've got a strong case, which is to say, if you've been waiting 5, 6, 7 years for action, you're probably going to win that case in federal court. And the government knows that, so they would rather just give you your interview or give you a decision than fight with you in court, because that's costly and time consuming. It's kind of a big deal. So often when someone does present a lawsuit, the government just says, okay, we'll give you your interview, or we'll go ahead and get the decision to you. So those are the main elements of the pressure route. You're trying to pressure the government to act, to do what they're supposed to do. Now, there are a couple of other things that people sometimes try. I think that they're less effective. There's no real downside to doing them, except it could be a waste of your time because they're usually less successful. And that's enlisting the help of a congressman, a senator, or a representative in the district in which you live, whose office can inquire with the asylum office and just say basically, hey, my constituent, whatever your name is, has been waiting a long time. What's the status? And that could, I guess, in some cases help. But I actually worked as a congressional liaison with the asylum office. So I was dealing with these offices of senators and congressmen. And I can tell you from my experience, I just don't think that it's really that fruitful to invest much in going this route. But if you really want to get a result, it can't hurt, except for that, it'll take a little bit of time. And then there's also ways that you can inquire directly with USCIS about the status of your case and try to get movement. And that's through what's called a service request, which is basically an online form you fill out that says, hey, my case has been pending a long time, please look into it. Or you can ask for help from what's called the ombudsman, which is a person that's supposed to just deal with things that aren't going right at the agency and trying to help people who are dealing with the agency, like you as an asylum seeker, to get your case handled properly. I don't think that either of these is really that helpful. I think that the pressure path that I laid out earlier is a much more effective route for trying to get your interview or get your decision if your asylum case is pending for years or even really over 1 year. So those are the main ways that you can try to get action on your stalled asylum case. Let me know in the comments if you have questions about any of this stuff or you want to talk to me about your case in particular. I can tell you whether I think that you have a good chance of getting your case expedited or getting action on your case. And I'd also be happy to talk to you about the merits of your case, to tell you whether I think you've got a good chance at getting asylum and to talk with you about how I could possibly strengthen your case. So give me a call at this number that's on the screen, or find me on Facebook or Instagram. It's @ManningAsylumLaw is my handle, and just send me a direct message in either of those places, and I'll be happy to chat with you. Thanks, and until next time, it's my honor to serve you in your asylum journey.